For my clients, they find this kind of helpful when they're still sort of trying to build up a case for themselves to have kind of a list of what they need to start collecting. Hey, hi. Welcome to the workshop. My name is Verna Politan. I'm an immigration attorney. I've been doing this for about 20 years. Most of my practice is in the area of O1 visas. I do a lot of this type of visa for people in entertainment, including film, television, music, also the arts. So today I prepared a PowerPoint just kind of going over the O1 visa category, just so you, like I said earlier, to understand the components of what the O1 visa category entails. So the O1 is a non-immigrant visa. That means it's a temporary visa, and it accommodates a wide range of foreign nationals. It's considered an alternative to the H-1B because there's no wage requirement. So the H-1B is a visa category used by professionals. The L is for transferees within a company. And the E3 is a visa that's particular to countries like Australia and Singapore. There's no overall limit in terms of the time. So most other type of work visas, they have like a limited amount of time that you can be on the visa. So for example, like an H-1B visa, the cap is 6 years, and then you have to leave the country for a year before you can come back. With the O, you can get the O visa, and you can continually stay in the US indefinitely, as long as you show that you have work, okay? And no cap, meaning there's no limit in terms of the numbers of O visas that they make available. That's just the statutory authority. For some people that's interesting, but that's the section of the law that's in. And that there's the regulatory authority. That's what the USCIS is immigration. That's the Code of Federal Regulations, Department of State. So there are different categories within the O visa. So there's the O1, the O2, and O3. So the O1 is for people, and they say extraordinary ability, and I'll explain what that means later, extraordinary ability. But it's for people in sciences, arts, education, business, or athletics. And O2 is for people who are accompanying O1. So to give an example, say you have a band, okay, music band, and the principal, lead singer, or whatever, the band, he qualifies for the O1, but the other band members don't qualify for them. So they would fall under an O2 category. That's how you would get them into the country. And then the O3, this is the category for the dependents, spouses and children. Okay, so a main feature about the O1 is that you cannot self-petition. So you must have a petitioner, all right? So, and this goes across the board from any work visa. You have to have a petitioner. So they basically represent to immigration that the beneficiary meets the evidentiary, meaning the documents and legal standards of extraordinary. Extraordinary ability is the legal standard for this particular visa category. The petitioner can be an employer, a direct employer. For example, like in the film and television context, it could be like a production company or a director or filmmaker. Or an agent, like a traditional agent, or someone who is like a manager, for example, could also be a petitioner. Or just someone who's representing and who doesn't necessarily have a license to be an agent or a manager, but for the purposes of, and I can explain that later if you guys want to know, but someone who represents both the petitioner and the employers. So I can get into that a little bit later. In the application itself that you send to immigration, so you're here in the United States, for example, and you send out the application to immigration, the petitioner must show various documents such as like a deal memo. That would be so if it's an employer, then it's like a contract between them and the beneficiary. The beneficiary is the person applying for the O visa. The itinerary, which is important. So basically, it's an explanation of what the person is going to be doing on the O visa. That's what that itinerary is. And then the documentation showing that the beneficiary or the individual applying for the O visa meets the legal and evidentiary standard, okay? And then they also have to be responsible for signing on application forms and, filing with immigration. Okay, so let's go back to what does it mean, the legal standard of extraordinary ability. Okay, so it seems kind of daunting. So extraordinary ability, that idea, but there are actually few different definitions, actually three. So the first definition is it's a much higher standard, and this applies to scientists, educators, business persons, and athletes. So in this sense, extraordinary ability means having this expertise that you're at the top percentage of your field. So that's kind of the highest standard within this legal standard of extraordinary ability, okay? The second definition of extraordinary ability, it's a lesser standard, and this applies to artists and entertainers that not necessarily in motion picture, film, or television. And this can be like visual artists, for example, folk dancers or graphic designers, that type of thing. So the definition is a high level of achievement in the field of arts, et cetera, showing that they're substantially above those ordinarily encountered in the field, that type of thing. And then the third definition, and this applies, it's sort of the middle standard. So you have the highest standard applying to scientists and athletes, okay, you have to be that small percentage. You have this lesser standard saying that you just have to have sort of a high level, and then the mid standard applies to film and television. So it's anyone working within film and television. And what they look at is extraordinary achievement. That's what that extraordinary ability means. And it's a very high level, not just a high level, but a very high level of accomplishment in regards to the person's field. What is this evidentiary standard? Okay, I keep saying that. It's the documentation that you show in the application itself. So basically, it's the criteria of the O1 regulations. So the first one is you either show that the individual who's applying for the O1 has been nominated or has received a significant national or international award or prize. In film and television, that would be like the Academy Award. Okay, that's an example. Or, okay, so the big deal is you win a big national or international award, then you get the O visa. Okay, you qualify through that. But if you don't, then there's basically 6 criteria that they look at, okay? And you have to provide evidence that you meet at least 3, okay, of the listed criteria. And the first one is whether the person applying has performed or will perform services as a lead or starring participant in productions or events with distinguished reputations. The second criteria is evidence of national or international recognition for achievements through critical reviews or published material, and that's generally seen as press, okay? Newspaper articles about the person or their work. Number 3 is evidence that the person is commercial or success or critical acclaim. Number 4 is whether the person has significant recognition from organizations, critics, government agencies, or recognized experts. And that generally, that evidentiary criterion, you show it through recommendation letters, mostly. Number 5 is evidence that the person has commanded or will command a high salary. And then there is a last one that kind of is sort of comparable evidence. That's something that doesn't like a person's particular occupation doesn't necessarily fall within this criteria, or maybe they do something else in addition. Maybe they're a musician and in addition they do visual arts and they've won acclaim through that, you know. This slide, you're looking at the different criteria and the type of documentation that is acceptable. And for my clients, they find this kind of helpful when they're still sort of trying to build up a case for themselves, to have kind of a list of what they need to start collecting or considering to collect, okay? So for that first criteria where you have to prove that you've performed in a lead starring or starring participant in a production or event, they look at this type of documentation: reviews, advertisements, publicity contracts, endorsements. The second criterion, what I mentioned about the press. So, I mean, it's obvious they want either newspaper, magazines, or online articles. I mean, lately, it's interesting, you know, having practiced for as long as I have. You know, I started out with just the print, you know, for the most part, and online was just kind of starting. And then lately, I have clients who ask me questions like, what if I'm on a blog or something like that? Can I bring in Instagram? Or immigration, they're still trying to kind of grasp social media. I mean, you can try. submitted social media type of documentation to show that a person has national or international recognition, and it depending, like, so for example, O1 visas, it's like social influencers try to get this type of visa, and for the most part, a lot of it has to deal with like Instagram and likes and all that stuff, right? So I have to make kind of that argument. So it depends, on the occupation, but if possible, okay, they're still kind of mired, immigration's mired in sort of old school. If you have any newspaper or magazine article type of things about you or your work, that's kind of like what they prefer to see. And then they want to see, like, are these reputable, is this reputable media? Is this the kind of media that is considered major media that has like a certain distribution or circulation, So that's just something to consider. The third criterion, the documentation is like what they like to see to show that the person performed in a leading or critical role for an organization and establishment. So they like to see publicity releases or photo stills. Letters of confirmation, those are like testimonials. So for example, actress in like stage, theater, okay, that they performed in a leading role for the theater group, for example. That's an organization. Then, and if they don't have any publicity or something, then you could get like a letter, a testimonial letter from the director, or a testimonial letter from the producer of the show, or the theater owner, or something like that, okay? That's an example of that. So evidence of a major commercial or critically acclaimed successes. So, I mean, it depends on the occupation. So certainly, sometimes some officers are pretty strict about what they want to see. They want to see numbers. So if you're saying that you've achieved commercial success as an actor, they want to see, okay, what's your box office? Like, oh, you were on a television show. What were the ratings there? Like, what, or, if you're a musician, like, did any of your songs, were they in the charts or anything like that? But they do accept other documentation to kind of, if your occupation isn't quite, if you were to say, for example, say if you were like an artist, a visual artist, you don't get things like box office or ratings, but you get like these amazing reviews for some exhibition that you had at some highly rated gallery, then you kind of show that type of stuff. And these are the recommendation letters, pretty much, okay? So, and they can come from organizations, critics, government agencies, or other experts in your field. All right, so, and the recommendation letters, for the most part, they want to see that they're specific as to what you've achieved, okay, in your field. So not just letters saying, hey, this person's incredible, like, outstanding, nothing general. They want specifics, okay? The salary, obviously the best way to show it is through contracts or pay stubs. If for some reason everything you earned was verbal, then you get some sort of letter to verify it. And they may see it like a letter from an agent or a manager as having some credibility, or from the person who paid you, okay? And as I mentioned, comparable evidence. There's sometimes your occupation doesn't, you can't quite fit what you've done in your field neatly into the criteria that I went over. And say, for example, you're a filmmaker and you've shown your work at like the top film festivals, and you want to be able to say, hey, this is a pretty big deal because it's very difficult to get it into a film festival like that. Then that's where you make that argument. You may not have played like a leading role or maybe a starring role, but you were one of a select few that got into that. For people who don't have the evidentiary requirements for the O1, I've recommended that maybe an O2 is probably the best visa category for them. And it's not always the case where they know someone with an O1 that they can actually work with, because the idea is with an O2 is that you're working with an O1. Okay, but I mean, sometimes it does work out. Like, there have been in certain situations, like say in a film production or in a recording, like if you can get an O1 for like in the film, like for a director, and then you can get like the O2 for the assistant director or whomever, cinematographer, maybe they don't quite fit the O1 category. So those are examples in the music field, like, like for example, in whether in recording or live performance, you get one person on an O1, and anyway, everyone's working together. Get someone else under the O2. That can work with the O1. But the problem is with the O2, you're kind of tied to the O1, so that you don't have much flexibility. It's only for that particular project that you'll be working on. Now, as attorneys, we make the argument in terms of, you have the skills and experience with the O1 alien. Maybe you obviously have to be able to prove that. But I mean, if you do have the skills, and maybe if it's something that, it's a one-off, it's the first time that you'll be working with this person, maybe you don't really need so much experience, okay, with the O1 holder, okay? As long as you have like the kind of skills that are essential for the O1 to complete the project. Okay, so for the O1 and the O2 visa category, you also have to get a consultation from a labor union, or it could be a letter from the expert in your field. Why do you have to do this? Okay, so the reason that you have to do this is because when they created the O1 visa category, various unions, they felt very kind of protective for US workers, and they said, well, look, if you're gonna be filing all these O1 visas for foreign nationals, you have to allow the unions to kind of take a look at the application and then kind of determine whether this person really is qualified for the O1. So it's kind of like an acquiescence to the unions. So you kind of send them a copy of the application. They basically review it, issue an advisory letter saying, hey, we don't object, this is fine. You attach that to the application, you send it to immigration. So it's advisory only, it's not binding, it's advisory. If a union doesn't exist for a particular occupation, then you get a letter from an expert. So that's the purpose of why you attach a consultation to these applications. Okay, so this has changed. Regular filing has taken longer, especially in the past couple years, and that's just because of what's been going on with immigration and just a basic slowdown across the board. So there have been times over the years when it's gone really fast and slow, and this is the slow time. So that's what I mean by normal's regular processing. So nowadays it's taking about maybe 4 months, 5 months, or longer. And premium processing, that's a way to sort of expedite it, and you pay extra fees and you get a decision in, 3 weeks is roughly, less than 3 weeks, probably 15 days is when they usually make the decision. When you first apply for the O1, you try to get like 3 years, which is the maximum. Sometimes they'll give you less. Like, remember I said earlier how the itinerary is important? They want to know what you're doing. If they're not persuaded by your itinerary, they're going to give you less time, okay? But for me, I always try to get 3 years for my clients. I might as well try to get the maximum. So if you can get it, 3 years initial. Now, you can extend it for 1 year with the same petitioner, or if you get a new petitioner, you can extend it for an additional 3 years. So this is after the 3-year initial period. You can extend it in 1 year increments, or if you get a new petitioner, you can get it for another 3 years. And like I said before, you can keep on extending your O1 indefinitely as long as you can show that you have work, okay? For me, I've been able to get more than 1 year for if you have the same petitioner, as long as you can show that you have new events or new projects to work on. I'm open to answering any questions that you guys might have. The petitioner, as long as it's a US citizen, US entity, or it could be a green card holder too, it could be an individual. I have to kind of figure out with the occupation of, when I meet with a potential client, I try to find out exactly what do they do, And so, if you're in film or television, like the traditional employer is like a production company, right? Or maybe a director will just directly hire you to work on their team or something, right? It's project-based, exactly. Yeah, that's the ideal situation. Yeah. Most times people don't have that. And most times, especially people, they have maybe multiple employers. Maybe they have one job here and, 2 or 3 jobs going on. And in that case, you want a petitioner who's going to act like an agent, okay? And like I said, it doesn't have to be a traditional agent. okay? Or a traditional artist manager. It could be someone who is just acting within the limitations of the application itself, and they're saying that they're representing you and that they're representing the future employer within the application itself. But beyond that, they're not like getting anything like as an agent or a manager, because normally an agent or a manager would be getting like percentages of your fees or something like that. But in this sense, so the regulations are kind of broad about that, about agency relationship, and you can make the argument as a lawyer, and there's memorandum out there and the regulations we look at as well, but it's sort of a gray area. So as long as you can show within the application that the future employers, so you have multiple employers, that they recognize that this petitioner, this individual is representing both the applicant and these employers within the application, you make it very, very clear, then that's acceptable. I mean, as long as they're, like I said, a US citizen or a green card holder, that's it. Yeah. I mean, if this person has no relationship at all to the type of work that you do, we make it very clear in the application. This person is just an agent for the purposes of this petition, and that they have no relation, really, they don't, they're not involved in the business at all. Yeah, so you would present, I mean, there's certain, like for me, for my clients, I prepare, sort of deal memos or statements that kind of clarify the relationship. So you kind of, like I said, lay it all out in the application. Well, some people I know, if they know someone who has an O1 and they want to work with them, then maybe they could come in under an O2. What some other people have done, they've maybe gotten like a J1 visa just for a period of time to get some experience with a company, and then. But for the most part, I mean, it's not entirely inaccessible, this type of visa. I mean, it does seem, like I said, pretty daunting because the legal standard is what it says it is. But I mean, again, it depends on the occupation. Okay, so. Certainly, I mean, maybe you've talked and heard from other people like, oh, this person barely had any credits and they were able to get an O visa. But I mean, it really is about what kind of documentation they were able to show. That's the visa that people go for, like professionals and like, various professions and mostly technology. But the thing is, you have to show that the position that you're applying for is like a specialty occupation that requires the minimum of a bachelor's degree. And the O visa, you don't have to show any of that. You just have to show that, hey, that you meet, like I mentioned, the criteria, the evidentiary, and through the evidence, you say that, you make the argument that you meet the legal standard. That's how it basically works. So when you make the application for the O2, I mean, you're going to have to include in the application who you're tied to, so the O1, say the O1 visa holder already has their O1, right? Yeah. Okay. Sometimes O1s and O2s, they apply together. But say you have the O1, they already have their visa, right? And it's only for like maybe another year. Mm-hmm. So the validity of your O2 visa is tied to the validity of the O1. So maybe it's, so they're going to give it to you. Maybe they'll be doing other projects, but you can get it for the validity period of the O1. Before I file the application with immigration, we have to send a complete application to the unions. So like if you're trying to get an O visa as a writer, for example, I have to prepare the whole application and send it over to the Writers Guild for someone there to review. And then they issue a letter saying, oh, okay, this person definitely qualifies for the O visa, we don't object. I've had the most difficult time with Directors Guild. I mean, they're very protective, they're very arrogant. So for example, I've had situations where I've had to approach the Directors Guild. Say I have a director who's, he wants to direct a feature film here, but it's his first feature film, but he's got like experience doing tons of short films, tons of commercial films, etc. And I've gotten like a advisory opinion from the Directors Guild saying, oh, he doesn't have enough experience doing feature films. How dare he think that he can qualify for the O visa? And when I get advisory opinions like that, I have to refute them. I I have to address it, and then that's when I dig into the regulations and case law or whatever, just to make my point, and just I've had that a couple times. It's in the Immigration and Nationality Act. If you were to look into the Immigration and Nationality Act, or if you were going to uscis.gov, that's the immigration website, you can find some information if you were to do a search on the O1. It's kind of like it's a trainee visa, basically. It's like when you finish up a student visa and you have practical training, you get like a work authorization to work for a year. And that's kind of an addition to that, and you can get up to like 18 months where you kind of bypass going through immigration. You have a sponsoring organization, and then you have a company that you're working for, and you just apply for it through the sponsoring organization, and you bypass immigration. But it's a kind of a way to further so if you're a professional already, okay, and you want to, give an example, work in a production company and under like a J1, just to kind of enhance your career. And the production company agrees to it. They have a program that they lay out, and that's kind of what you do. And that's how some people maybe build up some credits. I mean, really, like I said, usually you get the practical training, the optional practical training. That's the work authorization that allows you to stay for 1 year after you complete your study. I mean, you really have to kind of use that year and to do what you can in terms of networking, working, getting, building up your credits as much as you can. And for some people, 1 year it doesn't happen, obviously, because of whatever circumstances. But you can do that, and it is only 1 year. Or what some people do, like I said, they try maybe to stay a little longer under a J1 visa. It gets tough for some people, and they end up having to go home and maybe build up their credits back in their home country, and then they can reapply like from there, So I've had that happen a few times.